The Judiciary Committee held a hearing on Guantanamo and made a field trip there. A number of us, including myself, went to take a look at Guantanamo, to see it firsthand and to question people there. I had gone there with the expectation of having a field hearing there. I wanted to hear from the officials at Guantanamo. And when I got to Guantanamo after the flight in, I was told there would be no field hearing, which was a disappointment and really contrary to what I'd understood the arrangement to be. But we held the hearing and have devoted a considerable amount of work to the issue, knowing that or thinking that the administration's military commissions would be struck down because they did so little, had no real relationship to due process, and we've prepared legislation. I had it put in final form last week when we considered the Department of Defense authorization bill, and one senator did talk about legislation, and I considered offering it at that time, but decided that it was not a good time to do so. But we have it ready to go, ready for introduction. Senator Durbin and I introduced a bill to handle the Guantanamo detainees on February 13th, 2002. And the issue was not picked up again until the Judiciary Committee held hearings last June. And this bill, which I'm introducing today, and I would ask the court reporter to strike the notation on the top of each page, discussion draft. It is not a discussion draft. It is a bill which I'm introducing. I believe will satisfy the requirements of the Supreme Court of the United States. This bill provides for two divisions. One is for the people who are charged and with specific offenses, and we retain the caption of a military commission. We provide that there would be 3 officers on the commission, 1 president judge presiding from the Judge Advocate General's office. An attorney will be provided for the accused. There would be competent evidence. There would be cross-examination, a unanimous verdict. In the event of classified information, we prescribe that the provisions of the Confidential Information Protection Act would govern, which is a statute which has been used in our courts for many years, which authorizes the presiding judge to sift through the information, make available to defense whatever is appropriate and not classified, and if it is classified, then to make it available at the discretion of the judge to the attorney. The attorney for the accused would be cleared through regular channels to deal with classified information, so that we would be protecting the classified information by having it viewed only by someone authorized to take a look at it, and having the maximum exposure practical so that the defense lawyer would be able to use it in the defense of his client. Not a perfect situation, but that's the way we have dealt with confidential information under the so-called CIPA, Confidential Information Protection Act. In our legislation, we also deal with the enemy combatants. These are the individuals who have been detained at Guantanamo under an arrangement where there is no limit as to the length of their detention. And that has caused considerable angst, considerable objection, but it is a very difficult matter. And when we are in a war fighting terrorists, and we should never lose our focus that we are in that war and that there are continuing dangers, and we have to protect Americans, until somebody has a better idea, they're going to be detained. Some have been released. and some of those released have been found on the battlefields killing Americans. So that the detention of enemy combatants is an ongoing problem. Our legislation provides that there would be a classification tribunal so that there would be a review of their status to make a determination on a periodic basis that they continue to be a threat to the United States, to be a threat either to us in the continent or a threat to go back and fight a war. We provide for an attorney, again an attorney who would be cleared for classified information. The issue of evidence is a much more difficult one because these enemy combatants are frequently taken into custody on a battlefield situation where competent evidence is not present. So we allow for hearsay. In the Supreme Court opinion, there is leeway granted to have sufficient due process on a showing of necessity. The Supreme Court found, for example, that the President had demonstrated sufficiently that there could not be trials in the United States federal district courts, so that ruling that out was fine, and was acceptable. And leeway, too, for some deviation from all of the generalized rules might be acceptable. They didn't really reach it because they didn't have a specific situation, but there'd have to be a showing of necessity, a showing that no other system would work. So in dealing with the enemy combatants, we're still struggling as to how to handle it. On the issue of indefinite detention, recognizing that they continue to be a threat. The legislation which I'm introducing today has received considerable thought and considerable analysis. And as I say, it picks up on legislation which Senator Durbin and I introduced on February 13, 2002. But it still requires a great deal more analysis and a great deal more thought, which we will give it in due course on the legislative process. We have altered our schedule in the Judiciary Committee to reserve July 11th for a hearing. Second day we're back, first day we come back on a Tuesday and really swing into action, where we will take up an analysis of Hamdan versus Rumsfeld in greater detail than we could do here this afternoon in a short floor statement, and with only a few hours to digest 6 opinions and 177 pages. And we will consider this legislation at that time. I ask unanimous consent that the full text of the bill be printed in the Congressional Record at the conclusion of my comments, and a short summary of the bill which will enable the reader to follow it without going through the extended text.
Without objection.
I thank the chair. I thank my distinguished colleague from West Virginia for waiting. I know he has an important speech to give. I just conferred with the senator from West Virginia, and it's his 4th of July speech. It's a little early for the 4th, but there may not be too many people in the chamber on the 4th or the 3rd or the 2nd or the 1st or even tomorrow, the 30th of June. So I compliment Senator Byrd in advance and yield the floor.